Mr. Oppenheimer.
May it please the Court, Acting Deputy Chief Justice and Justice of the Constitutional Court, I intend on addressing two issues. The first is who must determine a preferential procurement policy, and the second is who is entitled to be preferred under such a policy. I'm going to start with the second question first. So Section 271(2)(b) of the Constitution refers to the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. It must be noted that reference is not made to racial groups. Section 21(d)(1) of the Act states that the specific goals may include contracting with persons or categories of persons historically disadvantaged by unfair discrimination on the basis of race, gender, or disability. Now again, the Act doesn't refer to particular racial groups. It talks about people that have suffered unfair discrimination on these different bases. Furthermore, in the context of the Act, these specific goals are in relation to the points that can be allocated under a bid, and so it's either for the 10 points or the 20 points. No mention is made of pre-qualification criteria, or as Justice Jafta hinted at earlier, the idea of post-qualification criteria, the idea that an organ of state could hold in mind a particular racial group and then wait for all the bids to come in, only then to disqualify. No power is granted to the organs of state in that regard by the legislation. Now, the 2017 regulations specifically refer to race. So a tenderer having a stipulated minimum BEE score, or that when subcontracting that there is 51% black ownership. Now, if we contrast this with the 2001 regulations, these did not refer to racial groups. Instead, they used the term historically disadvantaged individual. So, for example, a South African citizen who, due to the apartheid policy that had been in place, had no franchise in national elections prior to the introduction of the Constitution in 1983, or the Constitution in 1993, provided that a person who obtains South African citizenship on or after the coming to effect of the interim constitution is deemed not to be an HDI. Now, this squares with the important value of non-racialism, which is in Section 1B of the Constitution, which says that the Republic of South Africa is one sovereign democratic state founded upon the values of non-racialism and non-sexism. And we must recall the importance of this rallying cry of non-racialism, and the Freedom Charter is a good document to have a look at to understand that term. And it says that South Africa belongs to all who live in it, black and white. The rights of the people shall be the same regardless of race. All national groups shall have equal rights. All shall be equal before the law. And all laws which discriminate on grounds of race shall be repealed. In 1991, the ANC produced a document entitled Constitutional Principles for a Democratic South Africa, which proclaimed that a non-racial South Africa means a South Africa in which all the artificial barriers and assumptions which kept people apart and maintained domination are removed. In its negative sense, non-racial means the elimination of all color bars. In positive terms, it means the affirmation of equal rights for all. With regards to the preamble, this again is mentioned non-racially. It says, "We, the people of South Africa, recognize the injustices of our past and believe that South Africa belongs to all who live in it, united in our diversity." Now, the Minister has referred to the matter of Van Heerden. I'd like to refer to that matter as well. In that matter, Justice Moseneke held that the long-term goal of our society is a non-racial, non-sexist society in which each person will be recognized and treated as a human being of equal worth and dignity. Central to this vision is the recognition that ours is a diverse society comprised of people of different races, different language groups, different religions, and both sexes. This diversity and our equality as citizens within it is something our Constitution celebrates and protects. In assessing whether a measure will in the long term promote equality, we must bear in mind this constitutional vision. In particular, a measure should not constitute an abuse of power or impose such substantial and undue harm on those excluded from its benefits that our long-term constitutional goal be threatened. And this is at paragraph 44 of the judgment. Justice Sachs, at paragraph 137, says that without major transformation, we cannot heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. At the same time, it is important to ensure that the process of achieving equality is conducted in such a way that the baby of non-racialism is not thrown out with the bathwater of remedial action. And in the matter of Pretoria City Council versus Walker, Justice Sachs held that no members of a racial group should be made to feel that they do not deserve equal concern, respect, and consideration, and that the law is likely to be used against them more harshly than others belonging to other race groups. In the Barnard case, Justices Cameron, Froneman, and Majid held that to achieve the magnificent breadth of the Constitution's promise of full equality and freedom from disadvantage, we must foresee a time when we can look beyond race. And Justice van der Westhuizen held that affirmative measures and their implementation are not immune from scrutiny, as is clear from the main judgment. The Constitution states that the measures must be designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination. Schemes and conduct based on race, which arbitrarily benefit some and violate the rights of others, can never qualify as a legitimate measure under Section 9(2). Now, these founding values of non-racialism must be used to interpret the rest of the Constitution. And if we apply these norms to the particular facts of this case, we can see that the pre-qualification criteria set out in Section 4 of the regulations exceed the powers granted to the Minister by Section 5 of the Act. The criteria refer almost exclusively to the racial ownership of the companies that are entitled to submit tenders. Now, the Constitution does not refer to racial groups, but instead rather to those disadvantaged by unfair discrimination. While it is the case that many people who are classified as black were disadvantaged by unfair discrimination, this is not necessarily the case for all people classified as black. The Act does not seek to advance members of particular racial groups. Instead, it gives preference to those who have suffered historical unfair discrimination on the grounds of race, sex, and disability. Black people are not interchangeable with each other. Justice requires compensating those particular people who were historically disadvantaged on the grounds of their race. It is unjust to compensate those who are not historically disadvantaged on the grounds of race, but happen to look like people who were. A black person who was denied the right to vote and the right to live and work in an area of their choosing because of their race is not the same as someone who was born after the fall of apartheid, participates in democratic elections, receives a world-class education at a private school, and lives in an opulent suburb and happens to be black. The 2001 regulations demonstrate that it is possible to target those who are historically subject to unfair discrimination on the grounds of race without referring to particular racial groups. The 2017 regulations restrict the power of organs of state to give preference to those actually targeted by the Act. Instead of assisting those who have been disadvantaged by undiscrimination, the pre-qualification criteria in the regulations target companies that tender for contracts which are 51% black-owned. This focus on racial ownership is a blunt instrument that serves to advance those who are already in a privileged position since they own companies. No mention is made.
Mr. Oppenheimer, your protection time has expired.
Thank you, Acting Deputy Chief Justice. No mention is made of those communities who are meant to be assisted by the projects which have been put out for tender. The narrow focus exclusively on the race of their owners flies in the face of the value of non-racialism as entrenched in the Constitution. Now, with regard to the distortion that happens in the marketplace, Section 271 requires that all government procurement must be fair, equitable, transparent, competitive, and cost-effective. Now, once a pre-requirement is put in place, what this does is that it narrows the pool of people that are able to participate in a tender. So the way that it works in terms of adding points is that, first of all, the person who comes in with the lowest price determines how points will be allocated going forward. So the person with the best price gets the full amount of points on price, either 80 or 90, and then the others get points on a pro rata basis depending on what price they put in. Now, if certain people are removed from the get-go, what happens is that it might be that points would have been determined by someone, let's say, who didn't have any BE points, but because they're not able to participate, points are then determined on price by someone who is allowed to compete. So this necessarily means that organs of state are going to be paying more for goods and services which are aimed at redressing the wrongs of the past and assisting poor and vulnerable communities. So if we think about a marathon, and we want the idea that everyone is free to participate in this marathon equally, we might think that in order to redress the wrongs of the past, that those that have particularly suffered wrongs are given some kind of preference in the marathon. In other words, they might get more time to complete or start further in the race. But to say that some people cannot participate in the marathon at all.
Mr. Oppenheimer, so to you, how exactly could protection and advancement envisage in subsection 2 play out? How exactly would it? Because Mr. Manager makes the point that established companies, for which I would say read white, will almost invariably undercut companies or smaller companies, for which I would say read previously disadvantaged, and in a large measure, I would say read black. They would undercut them when it comes to price, which means that some of them could even, I mean, and that's based on the economies of scale, because they are large, they may attract discounts, huge discounts, and therefore they are in a position to as I say, to undercut the smaller players in the field. Now, they could even go so far as to just not care about what falls under D, for example, paragraph D. If I get this 90%, or if I get this 80%, I'm home and dry. No matter what the others may do within the 10%, there is no way they will catch up with me, having gotten the 90 or the 80. The effect of which will be things will stay the same. Sometimes, these things get illustrated by anecdotes. As counsel, I was actually involved in 3 matters that fit exactly the point made by Mr. Maineche. That matter, a company that was on the opposite side, an established company, had tendered in the 3 contracts I'm referring to. And they put in an application, and they said, when those bids were opened, our competitors were these sort of companies, and their prices were these. Therefore, on point scoring and based mainly on our price, there's just no way that they could have given us, they could have beaten us. And therefore, based on paragraph F? And therefore, based on paragraph F, these 3 contracts ought to have been given to us. And they say that even before a Rule 53 record has been submitted. And I was on the opposite side. We had to settle those matters. But the short point I'm making is that business will stay the same. It will be business as usual, I want to say. And so it seems to me that that is what your argument is pushing for. How exactly do we achieve the protection? How exactly do we achieve the advancement if, based on your argument, things must basically stay the same?
Justice, let me address that in 2 ways. The first of all is to point out that neither the Constitution nor the legislation speak of set-asides. In other words, the idea that you can exclude people from participating in the process. In fact, if we look at all the cases that I've referred to on equality, the idea is that we don't exclude people on the grounds of their race, that we allow them to participate. But we want to have redress as well. And that redress is not done on the grounds of membership in a particular racial group. The question is, have you actually suffered an unfair disadvantage on the grounds of your race or of sex or of disability? And that's not coextensive. And as is used, if we look at the section, the 2001 regulations, we can see that there's a distinction drawn between people that were denied a vote under apartheid and those that weren't, even though they might be members of the same racial group. The second is to say that it's not the case that you're just going to have the status quo. You're affording a 20-point advantage to people that are in the preferred group. that strikes me as a significant advantage. And to the extent that it cannot be surmounted, well, then I would suggest that those companies improve their price. Ultimately, we must bear in mind that there is a cost.
Easier said than done. Easier said than done to just say improve your price, because in the end, you'll end up getting nothing out of the contract. That's easier said than done, Mr. Oppenheimer.
Well, Justice, I would submit that there is a cost in disregarding that structure. So, for example, we have to bear in mind that cost effectiveness is one of the requirements mandated by the Constitution, and this is being paid for by the taxpayer. In other words, there is a limit on how much of a role redressing the wrongs of the past can be played and how much has to do with service delivery going forward. And we must also bear in mind who are the beneficiaries of these services procured by the state. Often they are the poor and the vulnerable. And to my mind, in other words, if what you care about is redressing the wrongs of the past, it is those people who deserve the best possible service at the best possible price. Now, Justice, you had earlier stated that you could say that big business is white and that small businesses are black. I would submit the following, which is that you can have a business which is 50% white owned and 50% black owned. Because it is not 51% black owned, it can be excluded on the grounds of these pre-qualification criteria. And it can also be the case that every single employee of that business is black. Versus, let's say, a company where you have 51% black ownership and every single employee is white. So there's a distortion that goes on here. And again, as I stated earlier, if we take non-racialism seriously, it's not about the racial group that you're a part of. The determination must be more sophisticated than that. It must ask about...
The problem is, I understood you to be saying the best is having what we have. If you get into the detail of how, for example, the pre-qualification is done, that is something else altogether. If you say, but not like this, but to outright say pre-qualification is not at all envisaged in the Constitution, that's something else altogether. But the detail about the 50%, 51, and so on, that goes into how exactly do you do it? As I say, that's something else altogether. But at a conceptual level, I am not altogether convinced that the Constitution outlaws pre-qualification. I am not.
Well, Justice, I'd submit that it definitely doesn't cater for it explicitly. And it doesn't say that racial groups can be excluded from participation. It talks about preference. And there's a difference between a preference and a set-aside.
Category, not just preference. It talks about categories of preference. So you must interpret categories as well.
Yes, Justice. So the language...
It may be categories of disabled people, categories by gender, categories by race, or categories that include all of these and possibly more. Categories. So you must give meaning to that as well, not just preference.
Well, Justice, I'd submit that 2172A talks about categories of preference in the allocation of contracts. And then B specifically says the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. Neither of these refer to set-asides or pre-qualification criteria. There's a difference between preferring someone in the sense that they can do better in the marathon than saying that only those people can compete in the marathon. And pre-qualification criteria assert themselves to the level of a set-aside, and that certainly isn't mentioned at all in the Act.
My problem is I read, using your analogy of a marathon, I read your argument to basically say it's fair for somebody to say, let us run from Pietermaritzburg to Durban, but I'm going to start in Pinetown and you start in Pietermaritzburg.
Well, my knowledge of the comrades is not as good as Justice Malanga's, but my point is that, in other words, in awarding a preference, one can state that the following categories of people, which must be not racial categories, but people who've historically been disadvantaged on the grounds of race, those people can start ahead in the marathon. In other words, they get a 20-point or a 10-point advantage. So you might say, instead of having to do 80 kilometers in this marathon, you can do 65 kilometers. That you're allowed to do. But you can't say the following people don't get to compete against you.
In my analogy, the people that I was placing in Pine Town, which is very close to Durban, are your established white companies. That's who I was placing ahead, which is basically, a business being as is, business as usual.
Yes, Justice Malanga, if that is the quibble, then the quibble is with the way the legislation is drafted, which is that the way that points are allocated is either 10 or 20. It might be that other criteria could have been crafted by the legislature, but those are the criteria that have been crafted. It may be that the legislature had the power to have crafted different legislation, but this is the legislation that is there, and it doesn't make mention of...
I was just engaging you at the level that I thought you seemed to touch on what even the Constitution itself envisages or does not envisage, because you started off by setting out what you consider to be the applicable constitutional principles. That's the level at which I'm engaging you, not at the level of what the Act itself now says or provides for, if you see what I mean.
Yes, well then, Justice, at the level of the Constitution, I would submit the same, that the Constitution certainly doesn't envisage the idea that some people are excluded from participation in society on the grounds of their race. In other words, if we acknowledge that race and racism have been at the source of South Africa's many problems, we must accept that they cannot form part of our solutions. That the way through a non-racial society is to redress the wrongs of the past, but it is to do it non-racially. And it is not through race-based set-asides.
By the way, it's not as if the policy, or does it, or the regulations, it's not as if they are saying established white companies can never, ever, ever participate in procurement, do they?
Well, Justice, I'd submit that if the pre-qualification criteria are utilized, then it is quite strict as to who is entitled to compete. And so, for example, if black ownership is used as that requirement of 51%, or having a certain BEE status, then it may very well mean that they are excluded entirely from the participation. And that's very different from allocating a preference. Justice, I'd then like to turn to the first issue which I addressed, which is this question of who must determine the preferential policy itself. Now, the Act states quite explicitly that it is the organ of state that must determine its preferential policy. And I would submit that Section 2 is a special requirement, and that the power given to the minister in Section 5 is a general requirement, and the special must trump the general. Now, the minister then cannot exceed the powers which have been granted to it by the Act. And really what we have is there's a reason why the power has been granted to specific organs of state, which is to determine their policies, which is that they are better placed than the minister to determine their own procurement policies because they're embedded in local communities and are more sensitive to the needs of those communities. A rural municipality or a provincial department of health is more likely to know the consequences of procurement policy on those participating in a tender process and those that will reap the effects of the goods and services produced by the successful tenderer. The Constitution vesting this authority in specific organs of state rather than a single minister was therefore for a good reason. And if we bear in mind the sort of general reason why the separation of powers is important, the idea is that a concentration of power will most likely lead to self-interested action and an abuse of power for personal gain. Historical experience suggests that benign dictators who rule wisely, judge fairly, and generally advance everyone's welfare are very hard to find if such people ever existed. The underlying idea beneath any separation of powers doctrine is thus the skeptical assessment that good governance is more likely when political power is distributed between different institutions and persons. It means that specific functions, duties, and responsibilities are allocated to distinctive institutions with defined areas of competence and jurisdiction. So what we have here really is that the minister is trying to usurp the powers of the particular organs of state. Now, what's clear is that because the organs of state have the power to determine, what the minister has done, the legislation basically says the following, which is that organs of state, by analogy, are free to eat whatever food they would like. And the minister then says, as long as it is from this particular restaurant. So there's a constraining that happens. In other words, the minister says, well, the organs of state can choose whether they want to apply pre-qualification criteria or not, and therefore the discretion remains with them. But they can't determine the contents of that pre-qualification criteria. That has been determined by the minister. There is a closed list, which the minister has said it must be something off this list or not at all. Now, if the legislation is taken seriously, it means that the organ of state must have the power to determine, in terms of the Act, what those preferences will be and what the policy will be and what the specific goals are. And instead, what you have is the minister saying, well, you can have any goal you like as long as it's this one. And that really is to usurp the power that the organs of state have in terms of legislation. So I would submit that what the minister has done is really to create legislation, as opposed to amplifying the meaning of what exists in the Act. We find nowhere in this legislation the power to designate specific racial groups or to have pre-qualification criteria at all. And so regardless of what one feels about the morality of what the minister has done, one might think that this was a laudable aim. It certainly is beyond the minister's powers, and on that basis must be viewed as ultra vires. I therefore have no further submissions.